Okay, so thank you everyone for coming today. My name is Alex. I'm Adult Services at the Fox Lake District Library. We're going to present to you presenter Robert Monahan, who's going
Congratulations is because estate planning is a big deal. It's something that takes a little bit of nerve to get started with, and you should be proud of yourself for being here. And welcome and thank you for coming. Oops, hang on a minute. Let me get out of that. Okay, so it's a new year and this is a big step. Like I said, it's a congratulations because estate planning is a big deal. Almost 60% of American adults do not have an estate plan, and it can be scary. The reason it's scary is it involves big questions, questions like death and taxes, questions like who do you trust? Who do you trust with the lives of your children? Who do you trust with everything you've done with your life in terms of accumulating assets? It involves big questions, but during this program, I hope we'll come to see that not having a plan can be even more distressing than looking at these questions head on. So again, congratulations, welcome, and thank you for coming. We're going to have like 4 parts to the presentation today. First, I'm going to have a short introduction of me, which is going to be very short but very fascinating. Then I'm going to go over the 6 reasons to have an estate plan. Then 5 estate planning secrets that you may not know, and then a walkthrough of a simple will. And I prepared a simple will for Fred Flintstone, who is one of my favorite cartoons. Who am I? Robert Monahan, attorney at law, and I wrote a book last year that came out this year called Estate Planning Confidence. Okay, we'll talk about that in a minute. My motto is that no one should be so intimidated by the law that they fail to take steps to protect their families. My family is one of the most important things in my life. I'm married and I have 3 kids. They're 11, 13, and 15. They're all downstairs. I'm at home right now because there's a snowstorm coming and I didn't want to end up in a snowbank on my way home after work, so I left early. But my kids are also home. They're downstairs. They're all in grade school, and my oldest one is in high school. He's driving now, and I think he had his first class of driver's ed today. But my family is very important to me. It's very important to so many people, and I think people hate lawyers and hate the idea of going to a lawyer. I think they'd prefer to go to a dentist rather than a lawyer. And I'm not sure if they're intimidated by us or they just don't want to see us unless they have a really big problem. But the idea I have is no one should be so intimidated by the law that they fail to take the steps necessary to protect their families. So again, who am I? Back to that idea. I'm a practicing attorney. I grew up in Waukegan. I graduated from Carmel and Mundelein in 1992. I graduated from the University of Chicago in 1996. I graduated from the University of Virginia School of Law in Charlottesville in 1999. And I don't know, I mean, Carmel was a lot of fun. Chicago was not a lot of fun. It's known as the college where fun goes to die, or at least it was when I was there. And the University of Virginia was terrific. It was known as Thomas Jefferson's University. And it's one of the things he has on his gravestone is that he founded the University of Virginia. And that was a very nice place to be. Charlottesville, Virginia is beautiful. If you ever get a chance to go there, I would really recommend it. After law school, I started practicing law in New York City. That was in September of '99. And I was there in September 11th when that happened. And that was an interesting time. I left New York City. Oh, let me just say, while I was in New York, I met my wife. We had our first 2 children. I liked New York City a lot when I first got there, but once I got married, it became a different thing because we had our first baby, I think, in the first year of being married, and then we had our second one 2 years later. And so once you get married and have kids, the fun of New York City isn't the same. So I returned home in 2008. I think my father-in-law died in 2007 in August, and that was really our last tie to New York City. And when he passed away in August, we decided we would return home. And I had always wanted to start my own law practice. So I started my own law practice in Gurnee. I think I told you before, my motto is to help people become more comfortable with the law, to not be so afraid of it, to draw the sting a little bit of dealing with law and lawyers. So I have a TV show on Comcast 17. It shows every Monday at 5:30. It's called Everyday Law, and that's all the law you need to know. I think my motto used to be demystifying the law for you and your family, but I shortened it to the law you need to know. And here's my work address. It's in Grove Avenue in Gurnee. If you know your way around Gurnee, it's near the Wendy's, between the Wendy's and the bank. It's my office. And my telephone number is right there. Here's my most proud accomplishment of last year. I wrote a book called Estate Planning Confidence. A lot of people don't know where to start with estate planning. I think they know they need a will, but they're not quite sure what a will is or what it does or why they need it. They don't understand if they have one, how it changes their life at all. And it's important to know these things. So I wrote a book kind of answering 49 of the most common questions about estate planning that I get. I found that my clients would often ask the same set of questions, and I kind of realized that everybody has the same set of questions on their mind. And so I wrote a little book that's available on Amazon, full of 49 of the most common questions. And these questions were like, is an estate plan for me, and do I really need one? What are the steps in the process? What happens if I don't have one? And so on. The book's available on Amazon and as a paperback. On Amazon as a paperback and as a Kindle book. And I can get you one if you'd like. Are the 6 reasons to have an estate plan. And this is really contained in the chapter 1 of my book. And it's really important because people ask me, is this for me? Do I need this? What's its point? How do things change once I have it? And what should I be looking for to do with one? And it's really 6 things: protect your assets, protect your family, get organized, avoid feuds in the family. Family feuds is what I mean. Avoid chaotic self-help and get peace of mind. Let's see what we got here. First, protect your assets. So an estate plan delineates your wishes for your assets when you're gone. It states who's in charge for carrying your wishes out, so that your estate plan basically chooses an executor or a trustee, and they're in charge, and you choose that person. It protects your assets in this way too. Without a clear plan, opportunists and creditors can come out of the woodwork with no one there to guard your legacy and keep them in check. When you're gone, your debts have to be paid. Any debts that are outstanding have to be paid out of your estate. And one of the things you do with your estate plan is appoint someone to be in charge of watching over who asserts claims against your estate and whether they're legitimate and whether they actually need to be paid, and whether even if they need to be paid, the creditor will come after them, or will he just let it go? It's a little bit of negotiation that happens by your executor. And if you don't appoint someone to do that, like I said, opportunists, creditors can make claims on your estate that may not be legitimate, and you need someone there to protect your estate and keep them in check. And, protecting your assets, you have a legacy. Legacy sounds like a big word, but you do. You've put your whole life into your work. We spend more hours at work probably than doing anything else in life. And you want to ensure that your legacy is protected for your children or your family or your loved ones. And so that the majority of hours that you spent in your waking life are not for nothing when you're gone. So the first reason to have an estate plan is to protect your assets. The second reason, which is probably more important than protecting your assets for many people, is to protect your family. A will nominates a guardian for minor children. Okay, so there's no hassle or battle over who will watch over minor children if some terrible thing happened and both spouses were killed in an accident, let's say. Protecting your family also means giving your family a place to start after you've died. If you work with an attorney on your estate plan, your family will not only have someone to go to ask what they should do when you're gone, but they'll also have a map. And again, they'll have a map for things like who you wanted to be in charge, who you wanted to receive what, and who should care again for your minor children, like I said. Third thing is to get organized. I mean, you may know where all your things are on your desk and where all your documents are stored, and sort of you may have your own organizational system, but does anybody else know how that works in your office or otherwise? When else are you going to get all your legal papers together with the help of a professional so that your loved ones can locate them when they need one? And in this case, just so you know, there is the four corners of the documents: the will, the trust, maybe powers of attorney, and so on. But it's not just estate documents that need to be organized in an estate planning procedure. Your estate planning attorney will also talk to you about other items like 401k beneficiary designations, life insurance policies, title documents to your home, to your car, and other things. And one last thing, I do this for my clients when I work with them. I give them a planner, an organizer. It's called Peace of Mind Planner. And the reason I do this is I said earlier, my father-in-law died in August of 2007. And he was pretty good about doing a plan, but he did not organize things in any way for us. So he wasn't a computer guy, so he didn't have any computer passwords, but he had insurance policies on his life in different drawers. The utility bills were kept in shoeboxes under his bed. It was very difficult to assemble everything we needed to really administer his estate. And to this day, I don't know if we have everything. We did find a key to a safe deposit box, and I don't know for sure that we ever found the bank. I think we didn't find the bank. He didn't let us know where it was. So I help people when we finish up an estate by giving them a peace of mind planner, which is an organizer, because I've been through this process before. And an organizer is, it's a little bit like flesh on the bones. You need an organizer for internet passwords to Facebook, to Gmail and LinkedIn. You need your Netflix password to be shut down so you can shut down your Netflix account. If you have a safe deposit box key, you need to know where that safe deposit box is. There could be $1 million in a safe deposit box and you might not be able to find the bank and you just have the key. You want to know where all the life insurance policies are, who the insurance agent is, and so on, and where all the title documents are. So, so have an organizer in addition to just the legal documents are one thing, but helping your executor, who's the person that runs your estate, through an organizer is something that's really important. And getting organized in general is a really important thing that occurs through the process of planning your estate. Next, family feuds. This is I used to think this might be a boring area to practice in, but family feuds are tensions are always there, I think. And mom and dad often can act as a lid on tensions among siblings while they're alive. But when mom and dad are gone, these sometimes come boiling to the surface. And bickering, fights, jealousies, anger, grief, anxiety, all of this can go on in an estate process, even when it's planned very well. So having a plan in place can at least set things up so that the kids know what you wanted and they can argue and bicker. But has anyone, I would ask if I could talk to you, I would ask if anyone had seen the movie Knives Out. That's a movie that came out recently where there's a family of a wealthy man the wealthy man on the night before he dies cuts everyone out of his will. And the question is, was he murdered by one of his children? But anyway, I digress. It's a great movie, Knives Out, but having a plan in place can help settle things among your kids, and hopefully stop fighting among them. And having a plan in place can also prevent chaotic self-help. With no plan, there's just a lot of bad things that can happen. Fights over family leadership, creditors, like I said, coming out of the woodwork to claim things that belong to the state. One of the things that people don't know is that not only family members can open your estate and administer it, but if no one does that, if they just don't do anything, a creditor can come in and open the estate for you. And just to take a step back here to give some context, what opening an estate means is petitioning the court to give someone the authority to pay debts and then marshal assets for the estate and distribute whatever is left over after the debts have been paid. And if the family just takes the assets, if there are creditors out there, a creditor can go before the judge and tell the judge he hasn't been paid his debt or her debt, and that he wants the assets to be brought back into the estate through a process called a citation proceeding. And then he wants to liquidate those assets and be paid his debt. And the judge will let him do that. So if you have died and your estate, your children have kind of made a mad scramble for your assets and not paid attention to the debts, a creditor can come in and make them give everything back, and it can be just a nightmare. So hopefully that story just then, or that kind of idea just then, that self-help is a nightmare, will give you the idea that planning something can lead to peace of mind. By planning the estate, by planning your estate, you'll prevent problems like you'll protect your assets and your family, you'll get organized, you'll prevent family feuds, you'll prevent self-help. I think planning your estate is one of those things that we all know we have to do in the back of our minds and just haven't done yet. And tackling these open loops that we know inside need to get done is kind of can bring that peace of mind, at least in one area of your life, and make you feel good about yourself. So I think that is the end of that section. So that is just to review the 6 big reasons to plan your estate are: 1, protect your assets; 2, protect your family; 3, get organized; 4, prevent family feuds; 5, prevent chaotic self-help; and 6, get peace of mind. And so, okay. 5 estate planning secrets. These are things that might surprise you about wills, trusts, and power of attorney, and probate. First, intestacy, I think, is my first one. Whenever I move out of this question, there we go. The 5 secrets we will review today. 1 is intestacy. Intestacy sounds like a dirty word, but it's not. It just means that if you don't have a will, the state of Illinois has one for you. 2, your will doesn't cover everything. So we're going to talk about what property a will does not cover, and the document really only goes so far. So often people think once they've drawn up a will, they're done. But the key question you have to think about is a will does not cover all your property. And so there may be other things you need to do. 3, what key situations does a will not cover? And that's important because a will does not cover something very important that could happen later in life. I hope it doesn't happen. That's incapacity, meaning dementia, Alzheimer's. Maybe you're in an accident and you're in a coma, God forbid. But there are key situations a will does not cover that you might think it does. We should talk about that because you need another document to cover these situations, not just your will. A common misconception is 4, and that's having a will does not mean you avoid probate. Having a will probably means you still will have to probate your estate. And 6 is I'm sorry, 5. 5, the goal of a trust is to avoid probate. So, so intestacy, what a will does not cover, the key situations a will does not cover in terms of incapacity, how a will may mean you have to probate your estate, and how a trust helps you avoid probate. So first, intestacy, and that's the government's plan for you. Intestacy is the government plan. So people ask me sometimes, you know, I don't have a will. Does that mean the government takes all my stuff? Does the government get everything if I don't have a will? And the answer is no. You know, the government does not get everything you own if you don't have a will. It's more complicated than that. The answer is you do have a will. It's just that the state government has drawn it up. When you don't have a will, you're in the state of intestacy, and that means you don't have a plan that you've drawn up. However, there is a set of rules it's called the probate code called intestacy. These are default rules, and they are the rules that are the state's best guess about what you would want for yourself. These rules choose your administrator, they choose your guardian, they require a bond to be posted, and they choose the distribution scheme for your assets, for your legacy. It's better to be testate. Being testate means you have a plan because you're in control of everything. You can get out of the government plan by having your own will. Now back to intestacy for a minute. It's like being you have different legal statuses depending upon things that happen in your life. A simple legal status is the status of being a minor. Okay, intestacy is a legal status. Being a minor is a legal status. Being a minor means you can't own property. Being a minor means you can't vote. Being a minor means you can't drink alcohol. So once you turn 18, actually, except for alcohol, you get new privileges, and it's like presto changeo, you're now an adult and you can own property and you can vote, and you're no longer a minor in the eyes of the law because your status has changed. Your status, if you don't have a will, is that you're intestate. And until you draw a will of your own, the intestacy rules apply to you. And once you draw a will, presto changeo, you become testate. You have a will, you've kind of gotten yourself out of the default rules that the government has drawn up for you, and it's better to be testate. But one example of a reason it's better to draw up your own will is because the rule that the government, the state of Illinois, the legislators' best guess about what you want would not reflect what many people really do want. And an example is your distribution scheme. Your distribution scheme when you're intestate is that anything in your name, if you die in your name and you're married and you have kids, does not automatically all go to your spouse. In almost every will I've ever drawn up for married couples, everything goes to the spouse when they pass away. However, if you die intestate, half of your things go to the spouse, the other half go to your kids. It's a 50-50 split, and almost nobody wants that, especially if the kids are minors. It's a terrible situation. So it's better to be testate than to be intestate because the legislator's best guess about what you want are not right on the money. Two, the second kind of secret about estate planning that I think not a lot of people know is that your will doesn't cover everything. Your will only covers what are called probate assets. And probate assets are not everything you own, but only things that you own in your own name as an individual. Probate assets are only things that you own in your own name as an individual. Okay. In other words, if you have a will, it doesn't dispose of everything you want. The most important kind of concept for this area is that assets have different legal categories, and they pass differently on death depending on what category they're in. So let's look at them. So one kind of asset is an asset that you own jointly, sort of with a spouse perhaps. Another kind of asset is a beneficiary designated asset. A third kind is a trust asset, and a fourth kind is one that you own as an individual. So jointly owned assets pass to the other person by operation of law at your death and are not probate assets. So if you have a will and you have a son, and in your will you say, my property called Blackacre goes to my son, and you say that in your will, but you actually own Blackacre, this property, jointly with your spouse, it goes to your spouse, it goes to your husband or your wife. It doesn't go to your son through the will because it's jointly owned property and it passes by operation of law to your spouse. Similarly, if you have a life insurance policy and you say in your will, I want my son to get the proceeds from my life insurance policy, but you designate your wife as the beneficiary in the policy, that's what controls. So your will doesn't have anything to do with it. The life insurance policy proceeds will pass to your spouse because it's a beneficiary designated asset. Same thing is true of a 401k. It's a beneficiary designated asset, or a payable on death account of any kind, really. It goes to the beneficiary outside of probate, and your will does not control it. The third kind is trust assets. Trust assets are titled not in the name of an individual. This is more complicated, and we'll get to it in another lecture, I think, but they're titled in the name of a trustee of a trust. So they're not owned as an individual, they're owned as a trustee of a trust. So that's a technical thing we'll be getting to, I think, in another lecture. But these assets are also not probate assets. So they are not controlled by your will, okay? Only things owned by you as an individual will be controlled by your will and will pass through probate. So the thing about drawing up a will is when you have to know what's controlled by the four corners of your will and what's not. And there are a lot of moving pieces in estate planning. It's a craft. And one of the reasons it's a craft is because it's not only drawing up documents, but knowing how assets pass depending upon how they're held, and they can pass differently depending upon the different kinds of ownership interests that you may have in it. And so that's what makes it more complicated than people might think. And it's not always just a matter of drawing up a will and being done. That's my point. An estate plan must be more than a will alone. A will only covers certain assets, not all of them. And you have to take a comprehensive look at everything so that you make sure everything is covered. So number 3, what conditions a will does not cover. The condition that will covers is death, but you need additional documents for incapacity. And in some ways, I think the other documents might even be more important, because if you don't have a will, the state at least has a will for you. The state has the intestacy statute, which may not be exactly what you want, but it has a will for you. It doesn't have powers of attorney for you exactly. And I'll get to that in a minute. So a will is effective at death. And that means that if you're alive but incapacitated, your will doesn't govern the situation. And that's why you have to plan with powers of attorney. You'd think that your spouse could automatically make decisions for you when you lack capacity due to dementia, due to Alzheimer's, due to a coma, due to an illness. But it's not so. It's not so. To make decisions for you, your spouse would need to apply to the court to be appointed as your guardian. This is very costly, very time-consuming, and takes a lot of effort. So I did say that there's not a default set of rules for incapacity. There are guardianships for incapacity, but it's not like just an automatic set of default rules like intestacy. If you are incapacitated and you're married, your spouse to take care of you would have to apply to the court to be appointed as your guardian. And powers of attorney come in two flavors. There's the power of attorney for property and the power of attorney for healthcare. And the reason that is because there are two kinds of guardianship. There's the guardianship of the estate, which replaces the power of attorney for property. And there's the guardianship of the person, which replaces the guardianship for healthcare. So these things replace court proceedings. The powers of attorney replace the court proceedings that you'd have to undertake to care for someone if they're incapacitated. So just as estate planning includes planning for assets, it has to include for situations other than death too. So incapacity planning is part of estate planning. And most people just think of a will, maybe a trust, but powers of attorney are key to estate planning. Number 4, a will does not mean you avoid probate. And that's a common misconception. People think once I have my will drawn, we never have to do probate, and that's just not so. A will doesn't really have any legal effect until you've died. And even then, it's not really effective. What I mean by it's not effective is if your will appoints your son, let's say, as your executor, your son can't take the will to the bank and show the will to the teller and say, see, I'm appointed the executor. Let's empty the account and I'll take the money and pass it out to me and my sister, if you have a sister. You can't do that. The teller will look at your son and say, no, 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 no. I need to see the official document. And the official document are called letters of office. Okay, and the letters of office are issued by the court, the probate court, once they've seen the will, seen who's appointed the executor, and made sure the will has followed all of the appropriate formalities. So what would happen is the teller would ask to see the letters of office, and your son would have to go back, go to court, show the judge the will. She would have to say, yes, you are appointed the executor and I'll issue the letters of office in 2 weeks. Then when your son gets the letters of office, he would have to go back to the bank, show the teller the letters of office. Then the teller would release the funds, and your son then would be accountable to the judge for what he does with them. So he'd have to make sure to pay the debts of the estate before he pays off him and his sister with the remainder. So a will does not avoid probate. It almost guarantees it. Okay, and if there's any questions about that, we can talk about that when we get there. This is the key thing I think that a lot of people need to know about a trust, and that's a trust is what you use to avoid probate. It used to be that the point of a trust was to avoid taxes, but now the point of a trust is to avoid probate. It used to be that the threshold for paying estate taxes was very low, meaning that you didn't have to own a lot of property in order to be hit with sizable estate taxes at death. That these taxes were imposed on your estate when they transfer assets from one generation to another on death. So the threshold for paying estate taxes has risen and risen and risen. And I think now it's 11.58 million per person at the federal level, 4 million at the state level. So it's pretty high, so high that many people don't have to worry about it. So a trust used to be really used to avoid taxes, but now it's really more used to avoid probate. And how does a trust avoid probate? You have to think of a trust like a bucket or a bowl, and anything placed in the bucket is an asset that stays out of probate court. So anything in the bucket stays out of probate court. And that's because putting the assets in the bucket means you retitle the asset in the name of the trust, so you no longer own it. It's owned by the trust. So I don't know if you remember this, but we said that anything owned by you as an individual triggers probate, and that anything owned by you as a trustee of a trust does not. So putting it in the bucket means you retitle the asset in the name of the trust, own it as the trustee of a trust, and it's not your individual asset anymore, so it doesn't trigger probate. Let me see if I explain that any further here. I don't, so let me go back. Here's the basic idea of a trust. A trust has three players. It has a grantor, a trustee, and a beneficiary. And a trust is created if I gave A $10,000. I gave A $10,000 to hold for the benefit of B. And I said to A, I want you to hold this for B's benefit, A. I want you to hold it for B's health, maintenance, welfare, education, and hold that $10,000 for the benefit of B. I've just created a trust. I'm the grantor. I've taken $10,000 and given it to A. A is the trustee in this arrangement. So he is holding that $10,000, but he's holding it not as an owner, but he's holding it as almost a custodian for the benefit of B, who is the beneficiary. So I'm the grantor, A is the trustee, and B is the beneficiary. And those are the three players in a trust. In a probate avoidance trust, the family members, usually the spouses, wear all three hats at the same time. They're the grantors, they're the trustees, and the beneficiaries all at once. They take property that they own, give it to themselves to hold as trustees for their own benefit. And you may say, well, why do they do that? Why would they do such a thing? And so they give property to themselves to hold for their own benefit so that they can retitle the property in the name of the trust, right? They take their home, for example, and they say, we no longer hold this home as individuals. We hold this home as trustees of the Flintstone Family Trust. And that takes the home outside of the scope of the authority of the probate court. And that is how a trust works. I'll be talking more about that in another seminar here at the Fox Lake Library, but I hope that gives a flavor for what a trust is. It has three players, the grantor, the trustee, and the beneficiary. It has the trust asset, and you can create a revocable living trust. And what a revocable living trust is where the couple, the married couple, wears all three hats at the same time, gives their asset to themselves to hold and they benefit from that same asset. And that allows them to retitle the asset, which takes it out of the scope of the probate court's authority. So I hope that clears up what a trust is at least a little bit. So that is the part 3 of the presentation before we do a step through of a simple will of Fred Flintstone. So and let's go because we don't have a ton of time. Let's see here. Okay, Fred Flintstone's will, his last will and testament. Is I, Fred Flintstone of Bedrock, Illinois, revoke all prior wills and codicils and make this my will. We're going to talk about just a few sections: the preamble, the distribution section, the executor and backup, the guardian for pebbles, and the executor powers, and then we'll talk a little bit about signing the will. First comes the preamble, and I just said that. It's I, Fred Flintstone of Bedrock, revoke all prior wills and codicils and make this my will. The important thing is who this is. You don't have to go into too much detail. Just the first and last name and where he lives for Fred. What does he do? He revokes all prior wills and codicils and makes this his last will. So what? Well, what that does, it means if there's any wills out there other than this one, the most recent one is the controlling one. So sometimes there may be more than one document. Each will that you'll ever see starts out the same way by identifying the testator, that's the person making the will, and revoking all of the prior wills. Okay. This is the distribution and residue provision. And one thing I'm just going to take a step back and note here is that all of this will be available on a recording. So I'm going through it kind of fast now. to get through it within an hour. But all of this is being recorded, so it's going to be available on the recording that Alex is making for the library. So this is the distribution and residue section. Here we go. So the first section is about personal effects, and the personal effects all go to Wilma. And if she survives Fred, or if she predeceases me, to the children in equal shares. And just so you know, the children have been identified already as Pebbles. So they're identified right there at the end of section 1. My children on the date hereof are Pebbles Flintstone. The residue to the wife, if she survives me, another to the children. You have to say where the residue goes. So if you make specific gifts, if you make gifts of personal effects, you still have to say where the residue goes explicitly. If you don't say where the residue of your will goes, it's as though you didn't say anything about it, and that means the intestacy statute applies to it. It can be kind of a trap for the unwary in making their will. Anyone who makes their will on their own has to be wary of that. Executor and bond. My wife is the executor of the will. She's been defined as Wilma. If she can't do it, then Barney will do it. And no security is required. So the job of the executor is to carry out the directions of the will and administer the estate. It's a big job. You have to be good at keeping records, communicating about kind of complex subjects like tax issues and legal issues. One thing that people don't know, and this is something I mentioned in passing when I talked about intestacy, waiving bond is important, and every will waive bond. And here it says, I direct that no security on the executor's bond be required of my wife or my best friend Barney. That's the last sentence there. What the bond means is it's an insurance policy against stealing from the estate. And it's required in intestacy. So the more valuable the estate, the larger the insurance policy that the executor has to buy is. And that's a problem. So what a will does is waive the bond requirement so that it's not necessary, which is very helpful. Okay. And the guardian of a minor child. If my spouse does not survive me, Barney Rubble is going to be the guardian of Pebbles. Executor powers they're spelled out in the statute, but this will also names all of them, and they're sort of to sell, borrow money, mortgage property, settle claims, make tax decisions, distribute the residue of my estate to anyone that's supposed to get it, and so on. Like I said, the executor powers include authority to pay debts, to sell or mortgage property, to settle claims. Really, the executor needs the authority to administer the estate and do everything necessary for that purpose. Okay, that is the end of the presentation. I sped through that last section a little bit, and maybe I did it a little too fast. I wanted to get through it just so that I didn't go over time too much. Again, I'm Bob Monahan. Don't be intimidated by the law. Take the necessary steps you need to take to protect your families. I'll give out a free consultation if you'll do me the favor of, after watching this, evaluating what you saw at this website. Oh, hang on. There may be a chat question here. Okay. Oh, yes. Part 2 is coming up at the end of February. And part 2 is on trusts. Is that right, Alex?
Actually, part 2, let me just read it out. It's actually going to be on probate.
Oh, on probate. Okay,
Yep.
great.
So basically, it's you'll be covering when it's necessary on the process, the advantages and disadvantages, If you want to include a little bit on trust too, that'd be fine too. But it's going to be mainly focused on probate. So that's Wills and Basic Estate Planning Part 2 coming up Monday, February 22nd, 2021 at 4:00 p.m. So I just put the link in the chat. If you want to register, you could start registering today if you'd like, or wait as it gets closer. You can also, you'll get a notice through the digital newsletter too. But just want to let you know, Part 2 will be coming up, and then if we decide to do a Part 3, that'll be in the future. So
Great, thanks, Alex. Yeah, I forgot about the next one was probate. And probate, like we talked a little bit about it today, probably not enough, but it was it came up, and probate is the process of making the will effective through a court proceeding, and there's a lot to it, and it's interesting, and it's not one of the interesting things about probate is that it's something that has its advantages. So most people think they want to avoid probate at all costs, but one thing I'll be talking about next time is that probate does have its advantages. So, well, Alex, I think we did a good job coming in under time.
yeah, well, thank you, Robert, so much for presenting on the basic will and introduction to wills and estate planning. And thank you all for coming to today's program. Again, I will try to have the recording up in the next day or two. I'm going to probably post a link on our library Facebook page, but also if there's a way that you're not able to access through Facebook, I can also email you the individual, they call it an MP4 format. So I can email you the video either through like Google Drive or an attachment. So stay tuned. It will be showing up probably on the library Facebook page. If you just go to our website and click on our Facebook page. Next day or so. So just to let you know. And then just to stay tuned for the next Part 2 of the Wills program coming up February 2021. And then also another interesting program if you're interested tomorrow, we have a new database called Gale Legal Forms. I'll be doing a little video presentation at 5 o'clock tomorrow on the library Facebook page and also our library YouTube channel. And there's actually forms that are on wills actually in there. So it's just a little simple little tutorial I'll be showing tomorrow. So stay tuned and it'll be recorded. So it'll be on the Facebook page and also on the library YouTube channel. So thank you all for coming for today's program. Always check our website, the Fox Lake Library, for updates, our digital newsletter. Check out our social media. And with that in mind, is there anything else that you would like to add, Robert?
No, that's it, Alex. Thank you. And everybody, thanks for coming and listening. Have a great night.
You too. Everyone have a good night.